Well, welcome, everyone. Let me just then ask Jane to come forward for the invocation. Jane?
This Quester prayer is dedicated to all of our new Quest members in the last few years. I give thanks for the fellowship, food, the makers of our food, for this beautiful space, and for my colleagues around me here today. Let me always be supportive, kind, and constructive in our shared endeavors. Help me be a valuable contributor to this club. Help me accept and appreciate myself and all members and the perspectives we bring. Please give me an open mind and tolerance as I hear the views of others. Teach me to listen. May the knowledge I gain here give me a greater understanding of our world. When my time comes, I pray to embrace my assigned topic with grace and curiosity. Give me the tools I need for research, the vocabulary to write clearly, and the discipline to refine the product until it's my very best. And finally, Lord, I pray these words of St. Thomas Aquinas, patron saint of academics. Grant to me keenness of mind, capacity to remember, skill in learning, subtlety to interpret, and eloquence in speech. May you guide the beginning of my work, direct its progress, and bring it to completion.
Today's paper. Michael Horton is the presenter. The topic is the Second Amendment in the 21st Century. Michael Horton is an attorney in Fort Wayne. He graduated from Indiana University, Bloomington in 1967 with a degree in economics. He was a lieutenant in the Army from 1967 through 1969 and served in Germany and in the war in Vietnam. He attended law school at Indiana University, Bloomington and received his law degree in 1972. After law school, he was a staff attorney for 2 years at a federal war on poverty legal services program in Idaho and for 1 year in Fort Wayne, and has been in private practice since then. He has served on the boards of and as president of the Washington House Drug and Social Treatment Center, the Allen County Public Library Foundation, Friends of the Allen County Public Library, the History Center, and Lifeline Youth and Family Services, Incorporated. He's a member of the Allen County, Indiana, and American Bar Associations and enjoys reading, traveling, golf, and snow skiing. His legacy is 4 daughters, 3 golden retrievers from the same litter, that's interesting, 2 cats and 1 wife, Suzanne. All in one sentence, by the way. There is evidence that he is the fastest notary public east of the Pecos. And finally, when he was a part-time cab driver in college, he was required to join the Teamsters Union. As a Teamster, he does not expect to be trifled with. Well, Mike, it's time for you to give your paper, and we will all listen intently, and we will all behave.
The Second Amendment in the 21st Century. The Second Amendment to the Constitution was enacted in 1791 along with 9 other amendments at that time. The amendment reads as follows and is set forth on the attachment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Full disclosure, I am a moderate to conservative on many political, economic issues. I'm to the left of center on the issue of gun safety and am in favor of every gun safety proposal that is under discussion. I'm a member of the Brady Center, a national organization promoting gun safety. The Constitution was drafted in Philadelphia by a convention of delegates chosen by the legislatures of the several states. It was drafted in secret. The public was not aware of its contents until it was approved by the delegates on September 17, 1787. The Constitution did not become effective until at least 9 states ratified it, and then it was only operative as to the states that did so ratify. To facilitate the Constitution's adoption, promises were made to add amendments to the Constitution after its adoption by the required number of states. They were so adopted by the first Congress in effect under the Constitution, largely through the efforts of James Madison, at which time the Second Amendment became effective as part of what is now known as the Bill of Rights. The use of the term militia in the Second Amendment rather than army was not a casually made decision. The founders believed, most of them, believed that a standing army was a threat to liberty. They thought of Rome when under Caesar and the army, the republic became a dictatorship. They thought of the English Civil War when a military leader of the victorious Parliament army, Oliver Cromwell, became the ruler of England. A militia composed of citizen soldiers was considered generally sufficient for defense and would not morph into a tyrannical government. In keeping with the suspicion of armies, Article 1, Section 8 of the Constitution prohibits army appropriations for longer than 2 years. There's no such limitation on funding for a navy. It was considered from the beginning that the Second Amendment and its companion amendments were limitations only on the authority of the federal government and not that of state governments, which includes their political subdivisions. The ban on the establishment of religion in the First Amendment, see attachment, was aimed only at the federal government. At the time of its enactment, some states had established religions, and they were unaffected by that amendment. Enactment of modern gun safety laws began approximately 100 years ago. In 1911, the state of New York passed the Sullivan Act. The law required that persons could only own a handgun if it was licensed, and a person who carried a concealed gun in public could be convicted of a felony. 9 states followed with similar laws. The first significant federal law on gun safety was the National Firearms Act of 1934, proposed by President Franklin Roosevelt, and was part of his New Deal legislation. Although it is not widely remembered, as president-elect in 1933, Roosevelt narrowly missed being hit by an assassin's revolver bullet, which instead killed his companion in his car, Mayor Cermak of Chicago. His commitment to gun safety predated that episode. As governor of New York, he vetoed the bill, which would have eliminated the Sullivan Act. The 1934 Act was enacted in response to the highly publicized shootings associated with gangsters and outlaws, such as the St. Valentine's Day Massacre, Charles Machine Gun Kelly, Bonnie and Clyde, and Al Capone and his colleagues. The law provided registration requirements for machine guns and sawed-off shotguns and instituted a tax on such weapons, which could not be transported across state lines. The bill enacted was designed to tax machine guns out of circulation. The proposed law included a requirement for a permit to purchase pistols anywhere in the country, but opposition from gun owners and the National Rifle Association eliminated that from the law. The NRA, which eventually supported the final law, emphasized restrictions on gangster weapons rather than pistols. The legislation that passed doomed Roosevelt's hope for the enactment of a National Sullivan Act. Understanding the term machine gun is important when considering gun safety. The 1934 Act provided the machine gun as a gun that emits a stream of bullets with one pull of the trigger, an automatic. A gun is not a machine gun if a person must pull a trigger for each time a bullet is fired, a semi-automatic. The M16, once the standard rifle for the United States military, is a machine gun, since in one mode it is an automatic weapon, but with moving a selector switch it becomes semi-automatic. An AR-15, the civilian version of the M16, is a semi-automatic and is not a machine gun. A semi-automatic is only slightly less lethal than an automatic rifle. In the Miller case of 1939, the Supreme Court held that the Second Amendment did not afford a citizen the right to possess a firearm independent of it being linked with use in the military or in the militia. Jack Miller, a desperado who robbed banks to support himself, was part of the O'Malley gang that raised hell throughout the Ozarks. Miller was arrested for possession of a sawed-off shotgun that he carried from another state. The judge in the lower court ruled that the 1934 Act violated the Second Amendment. Justice James McReynolds was assigned to write the opinion for the Supreme Court. Justice McReynolds was not a supporter of Roosevelt's New Deal policies. He, along with 3 other conservative justices, who were judicial roadblocks to New Deal programs, prompted Roosevelt to launch his infamous court packing plan to increase the number of Supreme Court justices to counter the conservatives. Chief Justice William Taft considered McReynolds to be selfish, prejudicial, and one who delights in making others uncomfortable, a grouch. It's hard to believe that an attorney could be a grouch. And the most irresponsible member of the court. He often left the bench when a woman lawyer presented a case. When a distinguished black lawyer argued for the desegregation of the University of Missouri Law School, McReynolds turned his chair around so he did not have to look at the lawyer. When Jewish Justice Benjamin Cardozo was sworn into the court, McReynolds pointedly read a newspaper from the bench. He made it known that he did not wish to be around Hebrews. Concerning his outlook on life, somewhat surprisingly, McReynolds' opinion held that the 1934 Act was constitutional and that the Second Amendment did not protect the right to bear arms independent of militia service. The court stated that there was no evidence that the weapon in question is any part of the ordinary military equipment or that its use could contribute to the common defense. The other 8 justices who agreed with McReynolds included legal titans Chief Justice Hughes, future Chief Justice Stone, and former law professor Felix Frankfurter. Urban violence and the assassination of Martin Luther King and Robert F. Kennedy sparked new interest in gun safety legislation. The Johnson administration in 1968 proposed legislation to require all firearms to be registered and to require the rigorous licensing of handguns. Congress was not persuaded. Senator Frank Church, a liberal on many national issues from conservative out-of-doors Idaho, was opposed to these proposals, stating that licensing was an inconvenience. People in Idaho should not have to pay for the problems of others. Idaho does not ask to write the gun laws for California or Illinois. We only ask to be left the master of our own home. The Gun Control Act of 1968 was less comprehensive than what President Johnson wanted. The act established a federal licensing program or system for gun dealers and banned the importation of military-style weapons. It also prohibited persons from purchasing or possessing guns who were felons, mentally ill, fugitives, and people dishonorably discharged from the military. In 1986, a federal law was passed that prohibited civilian ownership or transfer of machine guns made after May 1986. In 1983, President Clinton was successful in implementing a ban on 14 types of assault weapons and passing the Brady Bill, which included a 5-day waiting period for the purchase of a handgun. The assault weapon ban expired in 10 years. That provision was part of a larger crime bill, as there was a general theme in the country to get tough on crime. In the 1994 midterms, many Democrats lost their seats in Congress, and the Republicans took control of the Senate and the House at the same time for the first time in decades. The crime bill, including the gun measures, were thought to have played an important role in the election. In the 2000 election, some believe that Al Gore's loss was due to his support for gun safety rights. In 2004, John Kerry supported renewing the assault weapons ban, which Republicans had let expire. During the ban, the number of mass shootings declined. One attempt to moderate his gun control image occurred when Kerry went goose hunting in Ohio shortly before Election Day. Coincidentally, that's in quotes, the adventure was witnessed by many members of the visual press. Notwithstanding the photo op, Ohio went Republican and carried the election for Bush too. From the Miller case in 1939 to Heller in 2008, there was very little litigation concerning the Second Amendment. In 1975, the American Bar Association saw fit to declare that it is doubtful that the Founding Fathers had any intent in mind with regard to the meaning of the amendment. The Supreme Court case of Heller decided in 2008 was the first of a trio of recent important cases concerning gun rights. The Supreme Court, by a 5-4 decision with Justice Scalia writing for the majority, which included Chief Justice Roberts, Justices Alito, Kennedy, and Thomas, stated the Second Amendment protects an individual's right to possess firearms and that the District of Columbia's total ban on handguns, as well as its requirement that long guns in the home be kept non-functional, even when necessary for self-defense, violates that right. Justices Stevens, Breyer, Ginsburg, and Souter dissented from the majority's decision. The majority opinion and the dissent in Heller focused primarily on the history of gun regulation. The issue is whether the Second Amendment protects the ownership and use of firearms, even if that activity does not relate to a person's participation in the militia. The majority, 5 very bright judges, believed it did. The dissent, comprised of 4 very bright judges, believed to the contrary. If there was a private right to gun ownership governed by the Second Amendment, it would become more difficult to enact legislation curtailing gun rights. Unsurprisingly, there are strong personalities with very different positions on the Second Amendment. Justice Scalia believed that Heller was the first serious discussion of the Second Amendment by the Supreme Court and was frequently dismissive of the dissenting opinions. Justice Stevens disagreed and believed that Miller was the first case. Recall in Miller, the Supreme Court upheld an indictment under the National Firearms Act. Justice Stevens, who served on the Supreme Court from 1975 to 2010, has written that Heller is the Supreme Court's worst decision of my lifetime. Jack Rakov, a professor of history at Stanford University, has written that the majority in Heller in this area are very poor historians. Warren Burger, a Chief Justice of the Supreme Court appointed by President Nixon, neither being soft on crime, said that it is a fraud to state that there is a private right to possess a firearm. There is a glaring example of poor scholarship on the part of a voice for gun control. A history professor at prestigious Emory University had his Bancroft Prize revoked when his research on firearms in the founding era was determined to be shabby, bordering on the fraudulent. When questioned about the data used to support his position that gun ownership at the founding was not widespread, he reported that some of his important research was supposedly lost in a flood. Other research was lost in an earthquake. No mention of the proverbial dog. The professor relocated to a less prestigious teaching establishment and also became a bartender. The Heller opinion is 152 pages long, and the issues were extensively briefed by both sides. In important cases, friends of the court, amicus curiae, submit briefs to the Supreme Court. There were 66 such briefs in this case. It is difficult to imagine an issue or historical fact that was not brought to the court's attention. The Heller opinions are worth reading as they illustrate that bright, knowledgeable people can differ on history and the meaning of words. Deciding constitutional issues is not like solving geometry problems where there's only one correct answer. In Heller, Justice Scalia stated that notwithstanding the court's ruling, the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any matter whatsoever and for whatever purpose. For example, concealed weapon prohibitions have been upheld under the amendment or state analogs. The court's opinion should not be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. He further stated that rights existing under the Bill of Rights are not always absolute. For example, the First Amendment, see the attachment, prohibits government from abridging freedom of speech. However, a person who lies to the FBI during an interview will not be able to avoid prosecution under federal law by asserting that he was only exercising his right to freedom of speech. The McDonald case was decided in 2010. It dealt with the gun laws of Chicago, which were similar to those of the District of Columbia. The important issue was that the gun law originated not from the federal jurisdiction of Washington, D.C., which was covered by the traditional meaning of the Second Amendment. Rather, in McDonald, gun laws were adopted by the city of Chicago, which was an entity created by the state of Illinois. The McDonald case was significant in that it applied the Second Amendment to the states. The original meanings of the Bill of Rights was that its protections were guaranteed only against federal government action. Gradually, the Supreme Court began incorporating different aspects of the Bill of Rights over time through the due process clause of Section 1 of the 14th Amendment, which became law in 1868. Most of the Bill of Rights are now limits on federal as well as state action. The attachment sets out Section 1 and the original text of the First and Second Amendments to the Constitution. The bold language illustrates how they read after the impact of incorporation. Probably the most recent Supreme Court case on incorporation of rights under the Bill of Rights originated in Indiana. The Supreme Court in 2019 held that the Eighth Amendment provision prohibiting excessive fines applied to state action. A judge involved in the case in the Court of Appeals, Indiana Court of Appeals, was Paul Mathias, who grew up in Fort Wayne. He was in the private practice of law in Fort Wayne and later became a judge in the Allen Superior Court. Mac Parker and John Burns were partners of his when he was here in Fort Wayne. When Barack Obama was elected in 2008, in his first 2 years, he had a supermajority in the House and had either a filibuster-proof Senate or close to it. President Obama had issued an approving statement about Heller, and he flipped several states in his favor with significant gun-owning residents. Two gun laws were enacted during President Obama's 8 years in office. One to permit guns in national parks, and the other to authorize Amtrak passengers to carry guns and check baggage. President Obama announced many executive actions in support of gun safety. Unlike executive orders, which have the force of law, executive actions are only statements of desired policy. The specter of 1994 was not lost on Democrats. The court was unwilling to hear many gun rights cases in the years after Heller, and it prompted Justice Thomas to describe the Second Amendment as a constitutional orphan. In 2022, the Supreme Court decided Bruin, its third major Second Amendment case in 14 years, and held that the right to bear arms under the Second Amendment included the right to bear arms in public. By a 6-3 majority, Justice Thomas wrote that history and tradition would be the determining factors in considering whether firearm regulation would run afoul of the Second Amendment. The court struck down a New York law requiring applicants for concealed carry permits to show proper cause, a special need to carry a gun above and beyond a basic desire for self-defense. The history and tradition test has proven to be difficult for lower court judges to pass constitutional muster. Gun restrictions within the scope of the Second Amendment must be deeply rooted in historical precedent. Governments defending gun regulations then bear the burden of showing that their laws are similar, or at least analogous to firearm regulations, widely enforced around the time of the Second Amendment's ratification in 1791. The opinion of Justice Thomas also stated that 1868, when the 14th Amendment was adopted, could be the historical baseline in determining what law to use. Since Bruin, federal judges appointed by Reagan, Clinton, Bush II, Obama, and Trump have experienced concern that the Bruin test is so unworkable that it results in courts issuing unreliable, unreasonable, and unjust conclusions. The title to one article and point is Why American Gun Laws Are in Chaos. A judge of a Circuit Court of Appeals said, "There is all this picking and choosing of historical evidence. This is too early, this is too late. The whole thing puzzles me." In searching for historical analogies, federal judges in 3 states refused to overturn assault weapons ban on semi-automatic rifles because the laws resembled 19th century weapon bans on 19th century restrictions on the carrying of Bowie knives. The knives were widely used in fights, duels, and other criminal activities. The Supreme Court has several opportunities to make decisions on some important gun regulations cases. In the Rahimi case, the court issued oral arguments in November 2023. A Texas drug dealer named Zachary Rahimi had a history of violence. A court issued Rahimi's girlfriend a restraining order against him and forbade him from owning a firearm. He violated the restraining order to stay away from the woman and then commenced to engage in several unrelated discharges of firearms. He was arrested and was charged with violating a federal law that prohibits a person with a domestic violence restraining order from possessing a gun. Rahimi is challenging that federal law as he says it violates his Second Amendment rights. The Fifth Circuit Court of Appeals agreed with him and is now being under consideration by the Supreme Court. On February 28, 2024, the Supreme Court heard oral argument in Garland versus Cargo case. This case is not a test of the Second Amendment, but it is a challenge to federal administrative action in declaring that a bump stock is a machine gun. The bump stock modifies a standard semi-automatic rifle by replacing a rifle stock with this device. This device gained attention from the Las Vegas mass shooting in 2017, when Stephen Paddock fired rifles with bump stocks, which enabled him to fire more than 1,000 rounds in a short period of time, which ultimately killed 60 and wounded approximately 500 people. In the Trump administration, the ATF adopted a rule providing that a bump stock is a machine gun. The new rule was considered unconstitutional by the Fifth Circuit Court of Appeals, and that case is now under consideration by the Supreme Court. Indiana has adopted a red flag law authorizing the seizure of firearms from demonstrably dangerous individuals. The Indiana Court of Appeals ruled several months ago that the law authorized the police to seize firearms from such person. No mention was made in the opinion about the Second Amendment or the Bruin case. With respect to the Second Amendment and other issues involving federal law, it's useful to know something about the federal court system. There are 94 district courts in the United States, and many states have more than one district. Indiana has two, the Northern District and the Southern District. Districts are frequently divided into divisions. The late William Lee was a federal district judge. District courts never cross state lines except for Wyoming's district, which includes small segments of Yellowstone National Park, which extend into Montana and Idaho. District courts are organized into 12 circuit courts of appeal. Indiana is in the 7th Circuit Court of Appeals, and the court is in Chicago. If a litigant is not pleased with a decision in the district court, it can be appealed to the respective Court of Appeals. And if there's still no satisfaction after that experience, the case can be appealed to the United States Supreme Court. The Supreme Court receives over 7,000 appeals every year and agrees to consider only 100 to 150. Before an appeal is heard by the court, at least 4 justices have to agree on that for that to occur. The appeals typically come from various federal courts of appeals and sometimes state Supreme Court decisions dealing with federal law. So much of the federal law, including gun law, is determined by what occurs in the district courts and the courts of appeals. If there are significant differences between important law and the circuit courts, the Supreme Court is prone to hear an appeal to create uniform federal law across the whole country on that point. The National Rifle Association originated as an organization that promoted marksmanship, hunting, and sports shooting. In 1934, the chief NRA lobbyist before Congress stated, "I have never believed in the general practice of carrying weapons. I do not believe in the general promiscuous toting of guns. I think it should be strongly resisted and only under licenses." That position has changed in that the NRA is now a strong supporter of gun rights as opposed to gun safety legislation. The NRA has frequently been effective in opposing gun safety legislation through its lobbying activities and its campaign contributions. The amount of funds raised by the NRA is historically much greater than the amount raised by gun safety groups. The decline in the popularity of hunting and the increased urbanization of the country has probably played an important part in increasing the public support for gun safety restrictions in national polls, but that has not always been borne out in legislation. The NRA's position once was that gun safety regulations, particularly widespread registration, would enable government to use gun lists to disarm the public and facilitate or solidify a dictatorship. That does not seem to be a current position of the NRA. Another argument is that any gun safety legislation would be the camel's nose under the tent, and no matter how innocuous a proposal might be, it would lead to other more restrictive legislation. Today it seems that the camel's nose is still an issue, but self-defense because of national exposure of significant crime is a reason frequently advanced for opposing any firearm restrictions. It is estimated that there are 400 million firearms in the United States. It's estimated there are 20 million assault rifles. There are roughly 50,000 gun-related deaths in the United States every year. Of that number, approximately 25,000 are suicides, none by assault rifles. The rest of the gun deaths are accidents or deaths arising in domestic situations and in criminal activity, robberies, gang activity, drug wars, murders. In 2021, according to the FBI, the number of deaths in active shooter incidents was 103. The number wounded was 140. In 2021, according to the FBI, there were 61 active shooter incidents. 60 of the shooters were male, 1 was female. Many of the firearms used in such shootings were handguns. The FBI defines an active shooter as one or more individuals actively engaged in killing or attempting to kill people in a populated area. Enhanced gun safety legislation and enforcement may have some positive effect in reducing gun violence, but the results may be disappointing for a long time. The nation's success in restricting the consumption of alcohol under prohibition and drugs in the ongoing war against drugs has not been awe-inspiring. Background checks may be helpful, but as presently configured, they only apply to gun dealers and not to casual sales or sales at gun shows where a significant number of firearms are sold. If there were a ban on assault rifles, it would be more effective to enforce than would be true of a ban on handguns generally. Considering how many assault weapons are in circulation now, even if a ban were instituted today, it would take years before the weapons in existence would age out and for their ammunition to be exhausted. Of course, there would be a black market in both, and smuggling, as there is with narcotics, and it would be difficult to make a difference in the near term. Although the actual number of people hurt is relatively small compared to suicides, traditional handgun violence, the mass shootings have introduced terror where none existed before. Before their advent, it was possible for many people to avoid gun violence by avoiding places and times where gun violence occurs, using more discretion in choosing domestic partners. A high percentage of murdered women know their killers, and keeping any firearms in the home under lock and key to minimize the chance of accident, particularly by young people, or suicide by a family member who would not be able to free up their use. But with mass shootings, everyone is at risk. Before, schools, churches, shopping centers, and stores were places where no one's safety was at risk. That is no longer the case. Holding people accountable for permitting or enabling firearms to be accessible for the wrong persons would be helpful to prevent some forms of gun violence. Recently in Michigan, not far from here, in a well-publicized case, a troubled teenager killed 4 fellow students in a school with a pistol bought for him by his parents. Notwithstanding ample evidence that their son needed help, the parents never sought it. Both parents were prosecuted and found guilty of involuntary manslaughter. The paper mentioned a couple days ago that they were both sentenced to 10 to 15 years in prison. In Fort Wayne, several months ago, it was reported in the Journal-Gazette, a father placed his 5-year-old son in bed with his head on a pillow, underneath which was a loaded pistol, of which the father was aware. The child found the pistol, shot and killed himself. The father was arrested. Segments of at least several recent generations have grown up in the country with few, if any, of the moral values necessary for individuals to participate in a peaceful, prosperous society. Among those values are the concern for the well-being of others and self-restraint. In Columbus, Ohio, 3 teenagers, while laughing, beat to death an elderly disabled person at a Kroger store at Christmas time. Last fall, 3 young teenage girls, again while laughing, beat to death a disabled person in Washington, D.C. Not all violence is gun violence. These stories are endless and troublesome, and although they do not always involve gun violence, they frequently do, and the availability of guns has certainly made the situations more tragic. After a shooting, and particularly a mass shooting, occurs, an investigation is made of the perpetrator, who frequently is a troubled young male who is not functioning well either through mental illness or from the effects of growing up in a dysfunctional family. Too many young males are spending an inordinate amount of time on cell phones, electronic games, less time on working, socializing, studying, playing sports, and generally being part of the community. The late James Q. Wilson, a former Harvard and UCLA political scientist and sociologist, stated that a young man growing up without a positive male influence in his life may turn out to be a barbarian. There was a movement in the 1960s and 70s, very well intentioned, to deinstitutionalize persons with mental illness. It was thought that too many were in asylums and that their issues could best be addressed and treated outside in neighborhood clinics. Consequently, many such asylums were closed, but few clinics were available to replace them. In the early 1990s, there was a boomlet for reintroducing orphanages to be a place where children living in dysfunctional families could be raised in a better environment than the failed home situations in which they found themselves. That idea was criticized some as a throwback to the age of what Dickens wrote about, and the concept was never really part of the national debate. An advantage of an orphanage program is that if children were in a group home as opposed to spread out into many different foster homes and communities, it would be easier for the state to ensure that the children were living in a wholesome environment. I have an uncle, and he and his brother were raised in an orphanage run by the state of Indiana in Knightstown. It was not the best situation they would have liked to have had, but it was the best one available to them. It was an institution that was well run, provided a good education, was free from violence, and all the other familiar ingredients that make for a troubled home. The students were close-knit and stayed in contact with each other after they graduated. Addressing the cultural deficiencies in our society is a heavier lift than passing gun safety legislation. Republicans typically are strong on identifying culture as a cause of gun violence and violence generally, but are not as interested in legislative action. Democrats typically are weak on identifying the cultural deficiencies as a root cause of violence, but are stronger on legislative action. It would be helpful if both sides elevated their weakest position. I earlier said that, made a reference to the loophole in gun sales. There's a background checks. There has historically been background checks for sales by gun dealers, but there was an exemption for gun sales through gun shows. Last night, the Biden administration proposed a ban on gun sales at gun shows without a background check. I tried to get something more recent than last night at 6 o'clock, but that's the best I could do. Thank you.